Hi, this is the last session of Hindu law. We will take a look at the generic topics that are left in the Hindu law, which are debt, antecedent debt, gifts, wills, and religious endowments, which are primarily public and private endowments. Starting with the debts, where we will talk about antecedent debts. Antecedent literally means prior or preceding in point of time, but the words antecedent debt, as used in Hindu law, implies two things. One, it implies antecedent in time, and second, it applies antecedent in fact in nature. That is to say, the debt must be truly independent of and not a part of the transaction impeached. Lord Dunedin defined the antecedent debt as antecedent in fact as well as in time. Thus, the two conditions are necessary. The debt must be prior in time, and the debt must be prior in fact as well. The Supreme Court reaffirmed that the antecedent debt means antecedent in fact as well as in time. That is to say that the debt must be truly independent of and not a part of the transaction impeached. The debt may be incurred in connection with a trade started by the father. The privilege of alienating the whole of joint family property for a payment of an antecedent debt is the privilege only of the father, the grandfather, and the great grandfather, or the son or the grandson only. Now, looking at the public endowment and the private endowment. In a public endowment, the dedication is for the use of benefit of the public. In a private endowment, the property is set apart for the worship of a family god. The essential distinction between a private and a public endowment is that in the former, the beneficiaries are definite and ascertained individuals, but in the latter, the beneficial interest is vested in an uncertain and fluctuating body of persons. The essence of public endowment consists in being dedicated to the public, and in the essence of any document creating the endowment, long user is the material factor from which an interface of dedication may arise. The conduct of the founder and the descendants is very relevant. If they held the temple to a public one, a very strong presumption would arise. Moving on to the other two topics, one is gift and the other one is will. If you look at gift is a relinquishment without consideration of one's own right in property and creation of the right of another. A gift is completed only on the other's acceptance of a gift, so it follows the whole concept of offer and acceptance. Once it is accepted, then it becomes a gift. Uh, there are certain properties which may be gifted, and there are certain which may not. A Hindu may dispose of by gift his separate or self-acquired property, subject in certain cases to the claims for maintenance of those he is legally bound to maintain. A co-personer may dispose of his co-personary interest by gift, subject to the claims of those who are entitled to be maintained by him. A father um, may by gift dispose of the whole of his property, whether ancestral or self-acquired, subject the claims of those he is entitled to maintain by him. A female may dispose of her istri by gift or will, subject in certain cases to the consent of her husband. A widow may, in certain cases, by gift dispose of a small portion of the property inherited by her from her husband, but she cannot do so by will. The owner of an impartial estate may dispose of the estate by gift or will unless there is a special custom prohibiting alienation or the tenure is of such a nature that it cannot be alienated. A gift under Hindu law need not be in writing. However, a gift under the law is not valid unless it is accompanied by delivery or possession of the subject of the gift from the donor to the donee. However, where physical possession cannot be delivered, it is enough to validate a gift if the donor has done all that he could do to complete the gift, so as to entitle the donee to obtain possession. Gifts to an unknown person can also be done, or actually cannot be done. Under pure Hindu law, a gift cannot be made in favor of a person who was not in existence at the time of the gift. Moving on to the will. Will is the legal declaration of a person's intention which he wishes to be performed after his death, and once the will is made by the testator, it can only be revoked during his lifetime. A person cannot give his ancestors property in the form of a will, but he can make a will only if only of his self-acquired property. A will does not involve any transfer nor affect any transfer interviews, but it is an expression of intending to appoint a person who will, after the properties, after his death, a will regulates the succession and provides for succession as declared by the testator.